Ready, start. Learned Counsel further submitted that it is not necessary for a person claiming injunction to prove his title to the suit property, and it is sufficient that he proves that he was in lawful possession of the same and that he was dispossessed by a person who was not having any title over the property. Full stop. The law is clear that a suit for injunction was maintainable, and the issue of title was not directly and substantially involved in the suit. Full stop. It is further stated that the High Court exceeded its jurisdiction under Section 100 of Civil Procedure Code, 1908 by entering into the question of facts and travelled beyond the pleadings, which was not subject matter of any issue, and has upset a well-reasoned judgment which was upheld by the First Appellate Court. Full stop. Learned Senior Counsel for the respondent submitted that the appellant was never in possession of the property which was owned by the respondents. Full stop. The burden of proof in a suit for title and possession lies on the plaintiff, and he/she is supposed to prove his title to the suit property by clear evidence. Full stop. Further, it is well settled that revenue records do not confer any title. Full stop. To buttress this submission, the learned senior counsel had relied upon the judgment of this court in the case of Union of India and others versus Vasvi Cooperative Housing Society Limited and others. Full stop. Learned Senior Counsel further submitted that the suit property is in possession of respondent number 1, and therefore, it raises a strong and clear presumption in favor of the respondent number 1. Full stop. The counsel also submitted that the appellant had filed a suit against the owner of the northern half of the property bearing number 111 against one Vedavati, which was dismissed by the Court of Civil Judge, observing that the plaintiff had failed to prove his title to the said property. Full stop. It was vehemently submitted by learned senior counsel for the respondents that the plaintiff miserably failed to produce any material before the trial court to establish the factum of his possession over the suit property. Full stop. It was submitted that the documents which were relied upon by the plaintiff were only the extracts of the revenue record. Full stop. The plaintiff before the trial court had examined 5 witnesses apart from the revenue records. Full stop. The evidence on record does not prove that the plaintiff is the owner of the suit scheduled property. Full stop. The courts below have failed to consider this. Full stop. The trial court should have considered all issues separately, but has failed to do it. Full stop. It is relevant to note, there is serious dispute with regard to title of the suit scheduled property. Full stop. The plaintiff has not sought for declaration. Full stop. The courts below were not justified in holding that the plaintiff is owner of the suit scheduled property and he is entitled to recovery possession. Full stop. Admittedly, the first defendant is in possession of the suit scheduled property. Full stop. The plaintiff cannot depend upon the weakness of the first defendant's case. Full stop. The plaintiff must stand or fall on the strength of his own case. Full stop. In the present case, the plaintiff has failed to prove that he is the owner of the suit scheduled property. Full stop. Therefore, the trial court as well as the appellate court have erred while holding that the plaintiff is the owner of the suit scheduled property and he is entitled to recover possession, and the sale deed executed in favor of the first defendant, that is, the appellant herein, is invalid and void. Full stop. At the cost of repetition, it can be stated that there was no certainty of the scheduled property. Full stop. Respondent number 1 in his written submission had said that the plaintiff failed to produce any documents of title. Full stop. The plaintiff also failed to disclose the date or year of the alleged double inverted comma oral partition double inverted comma close in the family. Full stop. It was also submitted by the learned counsel for the respondent that the so-called partition deed placed on record at Exhibit 7 relates to entirely different property and it is in no way related to the suit property. Full stop. Another interesting feature which is revealed after perusal of the written submission is that the plaintiffs have filed another suit against the purchaser of northern half the property bearing number 111 full stop. The said suit was numbered as OS number 108 of 2003 in the court of civil judge full stop. The learned civil judge, Pandopura, by his judgment and decree dated 2/3/2024 dismissed the suit filed by the appellant dash plaintiff against the said Vedavathi, holding that the appellant dash plaintiff failed to prove his title to the said property. Full stop. Thus, in the cognate suit also, it is held that the appellant dash plaintiff has no title to the northern half of the very same property. Full stop. The copy of the judgment and decree dated 2/3/2024 is also placed on record along with the written submissions. Full stop. The learned trial court on evaluation of the material answered the issue in negative. Full stop. In the said suit also the documents in support of the submission of plaintiff were the extracts of the assessment register. Full stop.